Good evening. My name is Josh Hetzler. I'm legal counsel for Founding Freedoms Law Center, and I'm a resident and parent in Chesterfield County. I want to lay out a legal framework for you to think about, for you to use as you think about revisions to Policy 1015. State law is clear. The school board must pass policies consistent with the VDOE model policies. The current draft simply does not do this. For example, these policies do not protect girls from boys in bathrooms, locker rooms, or overnight lodging. They specifically say that a student can claim to be any gender without any substantiating evidence, and they do not provide adequate protections for parental rights. Secondly, as for federal law, the recent Title IX regulations on transgender students are not in effect in Virginia. A federal court suspended them in July in a case called Tennessee versus Cardona. Finally, much has been said about the Fourth Circuit opinion in Grimm versus Gloucester County School Board. I trust that you have all received our legal memo on the impact of that case. We know that this case is likely of no precedential value given the court's reasoning that led to its decision. However, even if Grimm were to apply, it only applies to a very narrow fact set. Notably, the court did not address the issues of locker rooms, overnight lodging, pronouns, parental rights issues, or athletics. The student in that case had received a medical diagnosis from a licensed medical professional, and parents were involved and in full support. The driver's license and birth certificates had been changed, and the student had undergone so-called gender reassignment procedures. Nothing would prevent this board from passing policies that align with the VDOE model policies while making narrow exceptions where it felt federal law so required. This board has no legal excuses to refrain from passing policies consistent with the Youngkin model policies, so I implore you to comply with the law. Thank you.